Okay. Beautiful. All right, Young. You're up.
You can see us okay now?
I can hear you and see you good.
Perfect.
Morning.
Good morning, Mr. Young. Can you hear me? Okay, Mr.
Yes.
Young?
Yes,
Okay.
I hear you.
All right, so all parties are here, so we are going to get started with your revocation hearing, okay?
Okay.
Good morning, I am Pio Meissner, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Young Cedric, number 250030. Today is July 14th, 2026. This hearing is being conducted via video at the BOPP Central Office in Osborne Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Cedric Young, 250030.
Thank you. And you have counsel here today. Can you please identify yourself for the record?
Good morning, Mike Valentino on behalf of Cedric Young.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which means releasing you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your parole officer is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present all relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay. The important rights today, which I'm now going to review with you. You have the right to have an attorney present. You have counsel here. You have a right to see the written notice that charges the violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you for the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
Okay, so we will now review the charge the state your parole officer is bringing against you and information underlying each charge. So charge one under release direction absconder, your charging officer reported on 2/26/26 at 8:30 a.m. You signed out of the Roger Sherman halfway house, your only parole approved residence at a community pass for a training at the Goodwill in New Haven. You were due to return back to the program at 6 p.m. Staff attempted to call your cell phone number, but weren't able to get through. At 8 p.m., this PO was notified that you did not return to the program. This PO tried calling your cell on 2 separate occasions, did not receive a call back. This PO, along with the assistance of other parole officers, went out into the community to attempt to locate you. As of this report, you have not been located and you have not notified parole of your whereabouts. Charge 2 under obey all laws, obedience to the law. Your charging officer reported on 4/15/26, you were arrested by New Haven Police for possession of controlled substance, failure to obey a stop sign, operating a motor vehicle without a license, and improper use of a marker plate. Charge 3 under additional condition halfway house placement. Your charging officer reported on 2/26/26, 8:30 a.m. You signed out of the Roger Sherman halfway house, your only parole approved residence at a community pass for a training at the Goodwill in New Haven. You were due to return to the program at 6 p.m. Staff attempted to call your cell phone number, but were unable to get through. At 8 p.m., this PO was notified that you have not returned to the program. This PO tried calling your cell phone on 2 separate occasions, did not receive a call back. This is a violation of your halfway house agreement, which states I will return to the halfway house for my community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I'm expected to be late and to receive a new return time. And the state has filed the following exhibits that are pre-marked for identification as Exhibit A, CT parole conditions, B, halfway house agreement, C, notice of parole violation, D, notice of parole rights, E, remand to actual custody order, F is the connection absconder incident report, G is rev hearing summary, 10/18/23, absconding. Exhibit H is revocation hearing summary, 10/6/25, absconding. Exhibit I, New Haven Police Incident Report ending in 4011, and Exhibit J is the parole violation report. Did you receive notice of parole violation report, and those other documents that I just marked, and did you review them?
Yes,
Okay. And there also was an addendum that was submitted by PCS. The addendum that was submitted by PCS states, in reference to the parole violation report submitted by P.O. Reeves regarding Cedric Young, the following applies. On 3/23/26, the Board of Parole issued a warrant based on the report declaring the offender an absconder from special parole supervision. On 3/31/26, the case was transferred to FIU for investigation. On 4/15/26, Young was located by New Haven Police and was arrested for possession of controlled substance, failure to obey a stop sign, operating a motor vehicle without a license, improper use of marker plate. A remand custody order was lodged with New Haven PD. Young has his next court date of 5/7/26 at GA 23. On 4/20/26, parole officer Rodney served Young as parole violation notices parole rights at New Haven Correctional Center. On 5/28/26, offender was seen for the charges of failure to obey a stop sign, operating a motor vehicle without a license, possession of controlled substance, and proper use of marker plate. For the charges of possession of controlled substance, he pled guilty and was found guilty and sentenced to an unconditional discharge. The charge of failure to obey a stop sign was not pursued. The above charges were under docket ending in 5478-S. Additionally, he appeared for the charge of operating a motor vehicle without a license. He pled guilty, found guilty, and sentenced to a $75 fine. The charge of improper use of marker plate was not pursued. These two charges under docket ending in 8767-X. Do you need to continue this hearing to obtain any additional evidence?
no, I don't.
Okay,
No.
we have no witnesses today. So it is now defense's opportunity. If you'd like to call witnesses, present evidence, and speak to any of the evidence submitted you may at this time. I will swear in Mr. Young in the event that you would like him to speak today. Mr. Young, can you please raise your right hand? You solemnly swear or sincerely affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, I do.
Okay. So I'll turn it over to your attorney. If you'd like to say anything at this time regarding the charges?
So we're not contesting the validity of the violation or the new charges at this time. I'd just like to take some time to speak about mitigating circumstances surrounding Mr. Young. As I understand it, we'd be doing that at a later point in this hearing.
Yes. So if there's nothing further in regards to just the charges, then I'll announce my findings now in regards to those charges that I just read on the record, and then we'll go into the second part. So regarding that charge one, condition of absconder, I do find you violated that condition based on evidence provided in support of that charge, which is exhibits A, F, and J, as well as an absconder warrant being issued by the parole board. On charge two, I do find you violated conditional bail laws, obedience to the law. This is based on your conviction of possession of controlled substance and receiving a sentence of an unconditional discharge. I do make a no finding in the motor vehicle infractions that it does not meet the elements of this charge. On charge three, I do find you violated additional condition halfway house placement based on evidence provided in support of that charge, which exhibits A, B, and F. So that concludes the fact-finding portion of this hearing. Before I make my recommendation, counsel will have an opportunity to speak to your background and history. The purpose part of this hearing is to help determine what outcome I will recommend. So if you would like to at this time, you may.
Certainly. Mr. Young has had a very difficult upbringing and a very difficult life. And part of the way he's coped with that is by turning to use of drugs, and unfortunately, and he spent a considerable amount of time trying to improve that aspect. However, he's had difficulties with that when he's been set loose in the special parole environment. And I think that's really where this whole incident stems from. He came into some money, and unfortunately, led by that addiction, he went out, grabbed some substances, and that's how he ended up with these charges, and that's really why he absconded. But he has recognized that's a problem. During his time in incarceration, he has maintained employment, but he's also entered into some programs. He completed the Voices program. He completed the Smart Recovery program. So really, I see an individual that, rather than presenting a danger to society as a whole, is more of somebody who really needs assistance battling his addiction. And I don't know if permitting him to more incarceration really serves that purpose. I would suggest instead that he be given an ankle monitor and some mandatory treatment as revised conditions of his parole. I think that would better serve the interests of justice and, help somebody who's had a difficult life really take the next steps and become a productive member of society.
Thank you. Is there future plans going back out? Are there anything that's set up right now at this time regarding treatment or housing, or are these things needed? Can you tell me a little bit about the release plan?
Yeah, I think these things would be needed. I think, ideally we'd be able to get him in some sort of inpatient treatment for drug addiction. I think that would be best for Mr. Young, and I think he would agree on that.
Yes.
If you were unable to go there immediately, which, are you clean in the facility? Have you been using in the facility?
No, I haven't.
So you had some clean time since you came in April, correct?
Yes.
So should you have to go to a halfway house first, I'm not saying that you're not going to do some type of inpatient programming, because you may be going there eventually if it's needed. But if you were to have to go to a halfway house, what area would you go to?
I would try to go to an area where I'm not familiar with this time, because I've been going to my hometown. So New London areas, somewhere
You want
around
Norwich?
there. Yeah.
Norwich? Have you been doing anything inside the facility since you've been incarcerated since April?
Yes, I've been going to NA meetings. That's the only thing that they'll allow me to go to, because I wasn't sentenced on this matter right here. But I've had a tierman job, a janitor job, for like a month in the beginning of when I was incarcerated. But I've been trying to keep busy. I've been reading, studying things that I'm trying to accomplish when I am released, as far as employment. But
Do you have employment opportunities when you're released at all? Or anything you want to do?
yes, I actually, I'm trying to I formed my LLC, and I wanted to start my own business. Unfortunately, the halfway house, they wouldn't allow me to pursue that until I'm released from the halfway house, but I formed the LLC. So I want to start a business as soon as I'm ready.
So that sounds like a good future goal, but you know that you're going to need probably to get started with something else. So
Yes.
do you have any more immediate thoughts on what you want to do when you get out for a job?
Any job that's willing to hire me, I'll take it. I don't have any.
Where were you working before?
I was working at Calabro Cheese in East Haven.
What did you do there?
I was actually a supervisor. I got hired there. I was cleaning machines, training people how to work the machines. I was there for 10 months, almost a year.
So you want to do something like that when you get out?
Yes.
Okay. Right. Is there anything else from either side at this time before I make a recommendation? Well, I mean from the attorney, or is there anything else you want to add, Mr. Young?
Oh, no.
No, we're all set. Thank you. I appreciate
Okay,
the
so
opportunity.
I'll be right with you then with the recommendation. I'm gonna put a few things on the record, because I've reviewed all the evidence that was provided by the state and I've listened to testimony today. I've announced my findings in regards to all the charges. So I am gonna tell you some things that are a concern to me. The fact that you were out there only 13 days before you absconded again for the third time while in this period of supervision is very concerning to me. You have returned with criminal charges multiple times. This time just resulting in unconditional discharge and a fine. You know you're not supposed to be operating a motor vehicle. Obviously, you don't have a license, you shouldn't be operating a motor vehicle. I do understand that you've explained that you have a problem with drugs and relapse has led to this. It seems you have a pattern of this that you've had for a while. And I would like to see you involved more in programming. Your officer recommended a year incarceration for this. I've looked at your past rev summaries in which you've came back. So I do note that you've done 6 months for prior sanction. I do see you've done 2 years for which you had a criminal sentence. So based on the totality of everything, I am going to recommend that parole be revoked and that you be re-paroled for February 16th of 2007. This is an approximate 10-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health treatment, medication compliance, and operation of a motor vehicle. I'm presenting this to the parole board on July 30th. So you will receive the official written decision from the board. You know the board can lessen that sanction. They can keep it the same as recommended, or they can impose a sanction longer than what I have recommended. If the board wants a longer sanction than what I've recommended, you're going to have a supplemental hearing. Before the hearing, the board would provide you with a written notice documenting the reasons why they want to exceed my recommendations. And during that supplemental hearing, you would have an opportunity to respond to those reasons while in front of the panel of the board. You are on supervision until 2032. So we have a ways to go still, and every time you abscond, you're stopping your time. So we don't want that to happen. We want you to be involved in treatment. Your parole officer's there to get you into treatment. So should you feel that you may relapse or you do, you talk to your officer there and get you in treatment. So it's important to do that. That's why the officer and the court system are working with you in the community to help give you this treatment that you have access to. So don't leave again and abscond, because every time you come back, I mean, not only you're stopping your time, but then your sanctions are going to gradually increase as well. So if you want to be out there and doing well in the community, stay involved in your treatment and work with your officer. Do you have questions?
Yes. Is there some way where I can go to like a sober house instead
Not
of?
unless you have a bed paid for. You have to have the bed paid for. And if you can get a bed paid for by the time you get out, then you may be able to discharge to, it's dependent, you gotta work with your officer, but that's a possibility, yes.
I will, I can have a bed paid if I must. I'd rather go to a sober house setting than a halfway house.
So if you can somehow get a bed paid for a sober house before you get out, you're gonna get in writing about a week after July 30th what the board's final decision is. You're gonna get that in writing from them, so you'll know when your voted to re-parole date is, if they do want to give you one. You do know the board can also revoke all special parole at any point in time they feel like you're not safe to be in society. So just be aware of that the whole time too, that you want to do well. You don't want to spend inside till 2032. So yeah, if you want to work on that, you may. If you can somehow, I don't know who your support system is. If you have a support system that would be able to help you in that, then they can. Just communicate with your officer when you get close to your discharge time.
Okay.
Okay. So like I said, you'll get it in writing about a week after July 30th, what the board's decision is.
Okay.
Okay. So you are all set for today, sir.
Thank you.
Good luck, sir. Best of luck. Thank you, Attorney Valentino.
Thank you.
Have a good day.
You too.
Mike, I'll call you later.
Yeah, give me a call later.
All right. Have a nice day.
You too.
Too.
Don't leave without your ID. Come on down.
Good morning, Mr. Oliver.
Good morning.
Morning, Attorney Jones, can you hear us okay?
If I can hear.
Oh, you're muted.
Oh, good morning, sorry.
Oh, there we go. Perfect. Morning, P.O. Walker.
Good morning,
hear
can
us?
you hear me?
Perfect. All right, everybody's here, so we are going to get started with Mr. Oliver's revocation hearing. Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Oliver Lamanta, number 382276. Today is July 14th, 2026. This hearing is being conducted via video at the BOPP Central Office in Osborne Correctional Institution. This is a public hearing. Public access to the hearing is available via video live stream. Please state your full name and DOC inmate number for the record, sir.
382276.
And we have a parole officer present today. Can you please identify yourself for the record?
Yes.
Natasha
No, not you.
Walker.
Thank you.
Natasha Walker from Parole.
Oh,
Service.
Natasha Walker.
Yeah, they're introducing themselves. And,
Yeah, that was for me.
yeah, so we have counsel here today. So can counsel please identify themselves for the record?
Yes, thank you. Attorney Sonia Jones for Mr. Oliver.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better leader evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to appropriate sanction. My recommendation will then be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge that the state appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present all relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all of the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure before we begin?
No.
Okay. You have important rights today, the right to have an attorney present, and you have counsel here. You have a right to receive the written notice that charges the violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence supporting your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
So we will now review the charge the state appeal is bringing against you and the information underlying each charge. Appeal Walker, if you please read the charges.
Sure. Obedience to the law. According to South Windsor Police, on or around 3/26/26, you sent a threatening text to a female victim which read, "B, I'm gonna kill you. Stop effing playing with me." The officer called you on the phone number that the message was sent from, and you admitted to using that phone number. The officer additionally gathered evidence of you allegedly holding firearms and photos, which you posted to social media. Subsequently, you were arrested and charged with threatening to physical threat.
And can you please read the addendum that was submitted?
Sure. On 5/28/26, Mr. Oliver appeared in Hartford Superior Court and pled guilty to threatening to physical threat. He was sentenced to 90 days jail. He has no further pending charges at this time, and revocation proceedings may continue.
Thank you very much. And the state has filed the following exhibits pre-marked for identification as Exhibit A, signed statement of understanding, agreement, conditions of parole. B, remand and custody order. C, notice of parole violation. D, parole violation report. E, arrest warrant application, South Windsor Police. Case ending in 5546. F, State of Connecticut BOPP written decision form. G is State of Connecticut BOPP decision information summary. And Exhibit H that was labeled is the JUD pending case details. Did you receive the notice of parole violation report, and those other documents I marked, and did you review them?
Yes.
And counsel has filed the following exhibit pre-marked for identification as Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses today. So at this time, I'm going to swear in Mr. Oliver as well as P.O. Walker in the event you would like to speak today. So can you both please raise your right hand? You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
I do.
Okay, so at this time, the state will have an opportunity, if you'd like to call witnesses, present evidence, speak to any of the evidence submitted, you may at this time. And if you'd like to speak in regards to the charge.
No.
I don't really have anything to add. I just think that this was a situation that was developing over a period of time, and he had an inkling and his mother was advising him on what to do. And because he didn't do it, it kind of escalated into this situation. So I would just advise him in the future to listen to his mom.
Thank you. It is now defense's opportunity. Excuse me, yes. If you'd like to call witnesses, present evidence, speak to any evidence submitted at this time, you may.
Thank you. The only comments that I have is the addendum is stated accurately in that my client did serve that 90-day sentence. I believe it was served as of July 12th. Thank you.
Thank you. And that is correct. It was completed on July 12th. Anything else from either side before I announce my findings?
Nothing further.
Nothing further.
Okay, so in regards to that charge one, I do find that you violated that condition, no bail laws, obedience to the law. This is based on your conviction of threatening second physical threat and received a sentence of 90 days jail, as well as exhibits A, D, and E in support of the violation. As I previously stated, this sentence was completed on July 12th of 26. That includes the fact-finding portion of this hearing. Before I make my recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. The purpose of this part of the hearing is to help determine what outcome I will recommend. So P.O. Walker, would you like to say anything in regards to the second part of the hearing?
I don't really have anything to add. He was doing well on supervision with me. The only thing he was continuing to work on was employment. But other than that, he was doing really well. He'd been out in the community for several years, living with his mom.
Thank you. So I'll turn over to counsel.
Thank you. My client is 33 years of age. He's single. He does have 6 children. He does have a strong relationship with all of his children. He has the support in the community of both of his parents who reside in Manchester, as well as his siblings. He was in the community having first been released to supervision on June 5th of 2019. He first went to a halfway house, Connecticut Partners in Actions in Hartford. He was there until September 20th of 19, and then he transferred to sponsorship with his mother's residence in Manchester, and he remained there up until the time of his remand. I believe he's been on parole supervision for approximately 7 years, and this is his first violation of that supervision. He does have a strong history of employment in the community. I believe he has a history of working at FHI Warehouse in Manchester, CNS in Windsor, Raymore and Flanagan Warehouse in Manchester, and at the time of remand working a seasonal job at Collegiate Landscaping in Glastonbury. As his parole officer has indicated, he was having much success in the community, but for this incident, I don't believe he had any prior, or it looks like he had one misconduct during the 7-year period of supervision in 2024 for failure to report, which is listed. When he's reinstated to parole, he'd like to sponsor back to his mother's residence. That information is contained within Defense Exhibit 1. He does indicate to me that he has employment to return to landscaping again at the Glastonbury location. We would be asking, he has been in custody now for approximately 3 months. That was the 90-day sentence that he received in court. Based on the length of time that he was in the community, which I believe he actually sets the record for me for clients having been in supervision for such a lengthy period of time. So based on all of those factors, and that how well he was doing, we would be asking that he be re-paroled at the next available date. Thank you.
Thank you.
Mr. Oliver, I don't know if you have anything that you want to add?
Just I learned my lesson from this situation, and my biggest mistake was not reporting first. That's about it.
Thank you.
What is the victim's initials? Does anyone have the victim's initials? What's her initials of the victim of your offense?
SF,
What's the initials?
SF,
SF?
SF.
I'm not sure if P.O. Walker or Attorney Jones, if you do have the name, if you would be able to send me the name.
Yes, I can do it. I just
oh.
don't have it in front of me right this minute, but I can
Okay,
definitely do it.
whenever you can, if possible. Okay.
Okay, no problem.
All right, so I'm just gonna put a few things on the record and then I'm gonna make a recommendation. So you were in the community for a rather long period of time, which I have yet is about 6 years and 7 months from your community release date that I have, which was in 2019. You are still on supervision until 2030 with us. You did receive the new conviction for threatening second, in which you did complete that 90-day sentence. There are no prior violations noted, and that one misconduct that was discussed is the only misconduct that was noted at this time. So you were doing very well, and that is good to see that you were doing so well in the community. So based on that, I am going to recommend that parole be revoked and be re-paroled for July 30th of 2026. This is an approximate 3.5 month period of confinement as a sanction. This is my next available board review date that I have. I recommend the following parole conditions: no consumption of alcoholic beverages, no contact with your co-defendants, Ricky Jordan, Louis Perez, and Rennie Stone, no contact with your victims, Sam's Convenience Store, 55 Oakland Street, Manchester, Lucky's Convenience Store, 42 Oak Street, Manchester, Quick Mart, 1 Broad Street, Manchester, Sunoco Gas Station, 484 East Turnpike, Manchester, and Lynn Garden, 846 Main Street, Manchester. A general contact with SF and Behavior Management Program for Domestic Violence. My findings are going to the parole board on July 30th. So you will, well, if the board agrees with me, you will be released on July 30th. They would release you that day, so you're not going to get notification from us because you will be released. If the board decides they want a longer sanction, you would be there past that day. And you would receive documentations letting you know why you would have to come in and have a supplemental hearing with the board. And the board would discuss reasons why they may want to exceed my recommendation. That's only if they want a longer sanction than the date I've stated. Do you have any questions, sir?
No.
Okay, so then you are all set for today.
All right, thank you.
Okay.
Thank you.
luck.
Good luck, Samantha.
Thank you. Have a good day, P.O.
Thank
Walker.
you. See you
Theo
soon.
Walker. Thank you.
Yep,
Alright.
take care.
5344, could I please get an escort?
Good morning, Mr. Davis.
Yes, good morning.
Good morning. We're gonna get started in 2 minutes, okay? Just have to wait till it's 9:45.
Okay, thank you. No problem.
All right, we're gonna get started with your preliminary hearing, okay?
Yes, ma'am.
Good morning. I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Davis Jamil, number 294905. Today is July 14th, 2026. This hearing is being conducted via video at the BOPP Central Office in Cheshire Correctional Institution. This is a public hearing. Public access to the hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Jamil Davis, and my inmate number is 294905.
Do you have counsel here today?
Yes, Hannah Dean on behalf of Mr. Davis. Good morning.
Morning.
This is a preliminary hearing, which is the purpose of Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is a procedure. I'm going to read you your rights. Then we will review the parole violation charge the state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to address the issue, probable cause, the severity of the allegations. At the conclusion of the hearing, I will inform you of my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay, your important rights today, which I'm now going to review with you. You have the right to have an attorney present. You have counsel here. You have the right to receive the written notice that charges the violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights? Are you ready to go forward?
Yes.
So we will now review the charge the state your appeal is bringing against you and the information underlying each charge. So charge 1 under bail laws will be into the law. Your charging officer reported at 5/28/26. Parole and Bridgeport Police Task Force members conducted a compliance check of your Reach apartment located in Capitol Ave, Bridgeport, Connecticut. A search of your bedroom was conducted by P.O. Rosa and assisted by Bridgeport Police Lieutenant. Inside a dresser drawer, Lieutenant located a green plastic container which contained several white paper folds of purplish powdery substance. The purple powdery substance was tested by police and indicated a positive response to the presence of fentanyl. You were arrested by Bridgeport Police and charged with possession of narcotics with intent to sell and possession of a controlled substance. You and the state has filed the following exhibits that are pre-marked for identification as Exhibit A, parole conditions, B, remand to custody, C, notice of parole violation, D, parole violation report, and E is Bridgeport Police Case Incident Report. Did you receive notice of parole violation report, and those other documents that I just marked? Did you review them?
Yes.
Do you need to continue the hearing to obtain any additional evidence?
Not at this time.
We have no witnesses today, so it is now defense's opportunity to respond, make a short statement, call witnesses, or testify with respect to probable cause and severity of the allegation.
Yes, thank you very much. As to the charges, I would just note that Mr. Davis is looking forward to working with his counsel in court to favorably dispose of those matters. We are also just wanting to take a moment to address some of the things that he was doing while in the community. My client at the time was working at ShopRite in Camden doing overnight shifts. He completed an intake assessment at J Brothers in Bridgeport per parole's recommendation and was recommended to engage in relapse prevention, which he then reported successfully completing. When he first started parole back in 2025, he initially was at the Isaiah halfway house and then successfully completed that. He then transferred over to a reach bed where he remained until remand. In addition to this, my client reports utilizing Project Longevity for added support, such as helping with getting his license. And he also had the support of his church community at New Visions International Ministries, which he attended regularly. On this period of supervision, he had no misconducts. I don't believe he's had any prior violations of this term of parole. Based on that, I would argue that the allegations are not serious enough to warrant revocation, or in the event that they are deemed serious enough, that he be permitted to handle the matter in the community. Mr. Davis, do you have anything I didn't cover that you want to say at this time? I would just ask you don't talk about the pending case in court.
I just need to swear you under oath if you would like to speak, though.
No, that was it.
Okay, thank you very much.
All right, so I'll be right with you with my findings. All right, so I am going to announce my findings in regards to that charge. So I do make a finding of probable cause on charge one, conditional bail laws, obedience to the law, based on the evidence that was presented in support of the violation, which is exhibits A, D, and E. And I do find the acts are serious enough to warrant revocation. Attorney should be detained while you wait for revocation hearing. The records office facility, as well as your parole officer, will be notified. At the rev hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked, whether any sanction should be imposed. So upon disposition of those charges, we bring you back to determine if there's a parole violation or not.
So Mr. Davis, if you or your attorney have any questions about, the pending case and how that would impact parole, just give me a call and I'm happy to discuss that with you.
Okay, no problem.
And as soon as that's wrapped up, we'll come back here for another hearing.
All right. Thank you.
All right, thank you.
You're all set. Good luck, sir.
Thank
Have
you.
a good day.
Thank you, you too.
Okay, regarding Scott Basil, inmate number 374211, we have counsel.
Attorney Alfonso Sirico from the Parole Revocation Unit on behalf of Mr. Scott Bazo. I am going to be requesting a continuance on this case, and the reason for the continuance is I did reach out to the GA for Waterbury clerk's office. Mr. Bazo is waiting a report from the medical team from CVH. That report was not ready for court yet. So his next court date is July 29th. I'm out of the office the following week, so I'm requesting August 11th for the next continuance on this case, and I will provide an update once I receive it.
All right, so I'm going to grant the continuance to August 11th, which is the next available hearing date after the first week of August for Scott Basil's preliminary hearing. So I'm now going to go off the record. Hi, good morning.
Good morning. Hold on, let me just see who walked in so I can tell you who I have so far.
Okay.
Okay, what's your name? So right now I have Staples Topier.
96, the building.
Yeah, so those are gonna be the only two that I'm seeing. Can I see Staples, please?
Okay,
Yeah.
all right, Staples.
It'd be the first at the end. Or I'll go and do your waiver after.
Yeah.
Morning, sir.
Morning, ma'am.
No, it's a little blurry. You can see us okay?
Yes, ma'am.
Okay. So we're gonna get started with your revocation hearing. Good morning, I am Pio Meister, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Staples Delmont, number 241014. Today is July 14th, 2026. This hearing is being conducted via video at the BOPP Central Office in the Carl Robinson Correctional Institution. This is a public hearing, and public access to the hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Delmont Staples 241014.
Do you counsel here today?
Sure. Attorney Alfonso Chirico from the Parole Revocation Unit on behalf of Mr. Staples.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence for the violation of one or more conditions of your parole, I'll reinstate your parole. It means at least you place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all of the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose of procedure before we begin?
No, ma'am.
Okay, important rights today. Right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, ma'am.
So we will now review the charge the state and false bringing against you and the information underlying each charge. So I will note for the record that the charge 1, residence, there's no finding made at the time of the preliminary hearing, so that charge is not taken into consideration today. Charge 2, under Obey laws, drugs. Charging officer reported you admitted using cocaine, Adderall on 5/2/26 and 5/3/26. You admitted using cocaine on 5/7/26, 5/8/26, and 5/9/26. The alcohol is not taken into consideration as no findings made at the time of the prelim. On charge 3, no consumption of alcoholic beverages. Yes.
Did you make a find that there was a no finding on the Adderall?
On the Adderall as well?
Yeah, that's what I thought we had. Second, just want to make sure.
Oh, yeah, and Adderall use. Yep, no finding in Adderall as well. So just fine, there's just charges of cocaine.
So no findings on the alcohol either, correct?
Correct.
Okay.
Yes. On charge 3, no consumption of alcoholic beverages. On 5/3/26, you consumed alcohol. On 5/7/26, 5/8/26, and 5/9/26, you consumed alcohol. Charge 4, halfway house placement, noting that no findings are made on the dates of 2/3/26 and 3/25/26. So those dates are not taken into consideration today. No findings are made at the prelim. So on 1/20/26, halfway house staff conducted a room search and found marijuana vape in your possessions. On 1/23/26, you were given a community pass to attend the Waterbury Reentry Center. You signed out of the halfway house at 12:43 p.m. with the scheduled return time at 3:30 p.m. Halfway house staff tried calling you at 4 p.m. and 4:15 p.m. You reported your meeting started at 3 p.m., but your pass was 1 to 3 p.m. Halfway house tried to contact program to confirm your attendance, but they were closed. Staff noted that the offenders who were scheduled for the same pass to the reentry center returned at their scheduled 3:30 p.m. time frame. Staff contacted you again at 4:48 p.m. You reported you were at the bus stop. Your pass was to walk to and from reentry center. You arrived back at the halfway house at 5:50 p.m. Halfway house did follow up with reentry, who reported programming was 3 to 4. You're 1 hour and 15 minutes uncountable in the community. On 1/24/26, you came to staff office and reported feeling targeted due to another room search. You were instructed to leave the office and you could file a grievance. You started swearing and told staff to F off and walked out of the office. You later returned and stated staff was prejudiced because he only finds out for Spanish offenders. On 4/24/26, you're aware you successfully completed CBT R&R group at AIC, but did not inform halfway house staff or parole. You used this to your advantage to have unaccountability in the community without halfway house or parole knowing your pass in the system was to sign out of work and to leave work at 3:30 p.m. in order to make group 5:30 p.m. to 7 p.m. You took advantage on the following dates and times. 4/27/26, you returned halfway house at 6:49 p.m. On 4/30/26, you returned 6:44 p.m. On 5/5/26, you returned to 8:15 p.m. So it would make you uncommon in the community for 11 hours and 18 minutes. You then signed out of the halfway house on 5/7/26 to attend work at R&R CPT, but failed to return until 5/9/26 at 2:41 p.m. You were unaccountable in the community for 1 day, 11 hours, 11 minutes. From aforementioned dates, you were unaccountable in the community for 1 day, 22 hours, and 29 minutes. And the state is following exhibits. Pre-marked for identification as Exhibit A, remand to actual custody. B, parole conditions. C, halfway house agreement. D, notice of parole violation. E, notice of parole rights. F, parole violation report. G, Chase Center incident reports dated 1/23, 1/24, 5/2, 5/7, and 5/9/26. Exhibit H, Chase Center residential disciplinary reports dated 1/20, 1/23, and 5/2/26. I, offender misconduct report dated 1/20, 1/23, 1/24, 2/3, 5/2, and 5/3/26. J, voluntary admission of positive test results for prohibited substance dated 5/3/26 and 5/11/26. K, emails from community partners in action dated 2/3 and 3/25/26. L, AIC discharge report. M, text messages from PO and offender, and N is Rev hearing summary. Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes, ma'am.
And council's following exhibits that are pre-marked for identification as Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement, and Exhibit 2, which is a support letter. You need to continue this hearing to obtain any additional evidence.
No.
We have no witnesses today, so it is now defense's opportunity. If you'd like to present evidence and speak to any of the evidence submitted, you may.
I have Mr. Staples put on those, please.
Mr. Staples, can you please raise your right hand so I can put you under oath? You can't hear me? Can you call the officer in, please? I'm gonna pause the record.
Right.
Can you hear me now?
Yes, ma'am. It
So
was
you
going
heard-
crazy. It was making a lot of noise. Brrr.
So your camera is off though. Is the officer in there?
No, I'll find out. I don't know, it just started going crazy and making mad weird noise.
You can see us?
Hold on.
Can you just hang up and we're gonna call you right back? Your camera went out.
Okay. Oh, wait, let me see. If I do this,
There you go. I can see you.
can you hear me?
Yes,
Okay.
perfect. That's weird.
Also, I can still see the camera.
Just ask him, make sure he can see and hear us.
Mr. Staples, can you see us and hear us now?
Yes, ma'am.
You were able to hear everything I said prior?
Prior, when you asked me if I received the paperwork and did I go over it?
Okay, so you heard me read the charges and everything.
Yes,
You
ma'am.
just couldn't respond back.
Yes, ma'am.
Okay, so that's good. So we will continue from where we left off then. I'm gonna swear you in so that you may speak today. Can you please raise your right hand? You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case will be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
I do.
Okay.
So, Delma, a couple of things first. I think I explained it to you when I spoke to you via telephone. The no findings that were made at the preliminary hearing, the ones that she mentioned today, that won't be used against you because no findings were made. You're aware of that, correct?
Yes, sir.
Okay. Just a couple of things under charge number 4, under halfway house placement. The incident on January 23rd, said you were given a community pass to attend Waterbury Reentry Center. Did you attend any groups on that day?
Yes, sir. I went
All right.
to my addiction service thing at Wheeler that I was supposed to do it from 3 to 4.
Okay, so you did attend, you did attend Wheeler Clinic from 3 to 4.
Yes, sir. They signed up, my caseworker called there, confirmed it, and Rachel and Taylor sat there and they both signed off on it, basically to throw it away because they confirmed that I was there.
Okay, so you didn't go, you were not at the reentry center on January 23rd, but you did attend Wheeler Clinic, and if this time frame is right, so the reentry treatment was the same time as your Wheeler Clinic?
I didn't know nothing about the reentry. That's why Aisha, my caseworker, sat there and called and confirmed everything, and they talked it out, and they basically threw it out because we all signed a piece of paper that was dismissing that charge.
Okay,
That misconduct.
All right, so you were at Wheeler Clinic between 3 and 4 p.m. on January 23rd, and you did attend the treatment, the addiction treatment that day?
That I did, sir.
Okay.
They called there and confirmed it.
All right. The January 24th, 26, that you were feeling you're being targeted with the room checks. How many room checks have they conducted in your room?
3 within the last 2 days.
Okay. Is a fair statement you got frustrated on that day?
I was very frustrated, and as I told Ms. Grant, that I overreacted, and I apologized to the staff.
Okay. The 4/24/26, regarding the incident where you were aware you successfully completed RNR group at AIC, but did not inform halfway house staff or parole. Did you have a sit down with your PO at that time regarding this situation?
The first day I met Mr. Parole Officer Parsons or Pearsons, he sat there, I confirmed with him, he checked an email stating that AIC sent an email that I was completed with that, and that's the day he called the central office, and because Ms. Jones was supposed to put me in for a reach bed on April 1st, and then he confirmed that she never did that, and he was like, "Oh, what an April Fool's joke that was." So yes, I did confirm it with him that day, my first day ever meeting with Mr.
All right. I don't have anything else to add regarding the first part. I just wanted to give you a little background information in my client's testimony, specifically on the January 23rd day. He did go to Wheeler Clinic and did attend group there on that particular day.
Thank you. So I'll be right with you with my findings. All right, so I'm gonna announce my finding, in regards to those charges that we are taking into consideration today. So that would be charge 2. I do find you violate conditional bail laws, drugs based on evidence provided in support of that charge, if it's B, I, and J, noting, alcohol and Adderall not taken consideration. On charge 3, I do find you violated condition, no consumption of alcoholic beverages based on evidence provided in support of that charge, if it's B, I, and J. Regarding charge 4, I do find you violated that condition halfway house placement based on evidence provided in support of that charge. Exhibit B, C, G, H, I, and L, noting the date 3/25 and 2/3 are not taken into consideration. That concludes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This first part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, on behalf of Mr. Staples, my client, he's 47 years old. He was born in Waterbury and he moved to Torrington. He does receive support from his mother, Miss Wood, actually currently in poor health, as well as fiance, Miss Donovan. Fortunately, his mother did suffer a stroke at the end of May and is currently residing in a rehabilitation facility in Sharon. He was her main caretaker when he was out in the community. He did report to us, he did obtain his GED. He did study computers at something community college some time ago. As far as his employment, appears he has a good work history when he's out in the community. 2013, he did establish his own small business, R&D Enterprises, to remodeling and home additions. And most recently did the Chase Center. Yes, he did obtain from the Chase Center, although my client did not have the proper ID, they were able to help him out. And he did obtain a full-time position at East Coast Container LLC, which is in Waterbury. He did report to us in April of 2020, did successfully complete the cognitive CBT at Community Partners in Action, the AIC. I think that's the one we alluded to. And also at Wheeler Clinic, he did begin in January of this year, did begin individual psychotherapy with Ms. Cass, and also relapse prevention with Ms. Sanchez. And he did report to us, he did complete that. As far as since he's been incarcerated, he does do the 12 steps independently. He did sign up, he's on the list. He would not actually put it in a program, but he did write to Addiction Services for programming, but he has not been put in anything yet. He would like to be sponsored by his mother, as I indicated. He was her primary caretaker. She's in a facility, but once he gets back out in the community, he can certainly help her out. And then he listed Miss Donovan as choice number 2, and her phone number is there. And if you do put a halfway house placement stipulation, he's requesting Waterbury, which is the closest to his mother. He's also amenable to utilizing the sober house. He does want to enroll in trade school to study plumbing. He's indicated to us he can return to his job at East Coast Container in Waterbury. His fiance has been in contact with the boss over there, and he is amenable to our treatment recommendation. I know in the parole officer's recommendation, these actions prove beyond a reasonable doubt to offend a serious addiction problem. My client readily admitted to me that there is an addiction problem, and he is willing to do treatment. He did complete the Wheeler Clinic, the AIC program. Unfortunately, he hasn't been able to beat it yet, but he is amenable to any treatment recommendation stipulations. Delma, anything you want to add about your background or what you want to do when you get out? This is your opportunity. We're not talking about the charges anymore, though, okay?
Well, like you said, my main thing is to work on my addiction. That's what I do every single day. I believe that my boss said he sent the letter to your office along with my fiance. He sent letters, support letters. He said that he's gonna hire me back. He has no problem doing that. I was a good worker. So my main thing is just to, like I said, work on my recovery because I just turned 47 years old and here I sit in jail for not being able to get my addiction under control. I felt that I was doing good when I was with my individual counselor, doing individual therapy with Ms. Sarr. And that's something that I need to continue to do is to have that in my life, I believe would work out well.
I appreciate your comments. As you said, but for this issue here, addiction, you wouldn't be here because there are no new criminal charges, thankfully. So hopefully when you get re-paroled at some point, you can get that under control. You're on supervision until May of 2030. I know you're aware of that.
Yes, sir.
I don't have anything else to add.
Okay.
I just wanted to add, wanted him to comment that not trying to hide he has an addiction issue. So a lot of our clients try to sweep it under the rug. Mr. Staples is very forthcoming regarding that.
Thank you. So I'll be right with you with the recommendation. All right, so there's a few things I'm gonna put on the record. I've listened to all the testimony today, reviewed all the evidence that was provided by the state. Some things that do concern me. You were only out there 4 months before you were returned to custody, and you were returned to custody for similar behaviors that you had, including in a prior violation, which you returned. Things like absconding, the drug use, the alcohol abuse, which you did discuss, you do have a problem with addiction, which I do understand. Unfortunately, you leaving and not continuing with treatment in the community has led you back to where you are, as well as some issues that you have with noncompliance in halfway houses. And unfortunately, due to your housing situation, which I have also read, I'm not sure if I'm gonna be able to go to your mother, especially if she's not there right now. So obviously, that may not be where you're gonna be going. So you may end up back in a halfway house at this time. And it is a concern because you seem to have a lot of problems in the halfway house. You do have that prior violation was criminal in nature, which you did end up receiving new charges. But the underlying behavior that caused all that, the same things you're continuing to do. So that is extremely concerning to me. You did receive 5 misconducts in this 4-month period of time. Your officer's recommending no less than a year incarceration. You seem to struggle on community release. I know there's at least 14 failures you've had on community release. So it seems like this has been going on for a significant period of time. And so that I do want you to receive treatment. Based on the information I have, I am going to recommend that parole be revoked to be re-paroled for February 9th of 2027. This is an approximate 9-month period of confinement as a sanction. I do want you to get involved in treatment, but I also want you to have time inside where you are sober and able to think about things better, maybe create a better release plan for yourself. I recommend the following parole conditions, which is halfway house placement if it is needed. Preferably in Waterbury, no consumption of alcoholic beverages, mental health evaluation, treatment deemed necessary, no contact with your co-defendants, Brian J. Strawn and Jennifer Skelton. My findings are going to the parole board on July 30th. So the board is going to review this. As you know, they can lessen that sanction, let it stand, or impose the sanction longer than what I've recommended. If the board wants a longer sanction, you'd come back for a supplemental hearing. And during that hearing, the board would provide you with written notice documents the reason why they may want to exceed my recommendation. During that hearing, you would have an opportunity to respond to those reasons while in front of the panel on the board. So just know that the board can always hold you in longer. They can revoke all your special parole I encourage you to work with your officer in the community to keep you in treatment, so that you can get the proper treatment that you need out there to stay sober. Do you have any questions?
No, ma'am.
You're gonna get this in writing about a week after July 30th from the board, what the final decision is, if what re-parole date they would like to give you, if they do want to give you a re-parole date, and your conditions would be noted on there.
Okay.
Yes, Mike, just clarify something regarding housing. I know you indicated halfway house stipulation if necessary or if needed
Yeah.
in Waterbury. Would they gonna look at the order we put things in? I know the mother.
Well, I don't have is there an address for this? I mean, do you want to not say the mother? I know.
No. I believe the way we listed it was this mother first and then this.
Yes, I'm gonna put all the mother's information.
Okay.
I don't have addresses or anything for the,
There's a phone number.
That's
So,
not,
yeah. Do you have Miss Donovan's address?
Well, she's in between. We're trying to get a bigger
Okay.
apartment between us.
Okay. All right.
We're
There's a
waiting to
phone
find out
number.
what's gonna happen with here.
Okay, then the field parole officer can look into that.
yeah,
But the halfway house in Waterbury, if needed, is the wording, correct?
yes,
Okay,
yes.
so Delma, you understand everything she said? It goes to the board, about a week after it goes to the board. You and I will get in writing if this is the recommendation, if it's more or if it's less, okay?
All right, and what was the recommendation again?
9 months, February 9th of 27 is the release date. If you want to call our office Friday, the 31st, at like 11, 12 o'clock, one of my secretaries can tell you over the phone what the recommendation, if it stood or not. Then we get an email, but then we get it in writing about a week later. But I know you're gonna want to know. I will
Yeah.
not be in the office, but call that day and one of the secretaries can give you that information over the phone.
Your secretary will probably have to email my counselor for that
Fine.
day.
Yeah, all right, let's see what we can do. If not, try to get a call in.
All right, thank you.
All right, all right.
Okay, you're all set, sir.
Thank you, ma'am.
Good morning, sir. Mr. Topper?
Yes.
I'll be right with you, okay? I just have to put a few things on the record that do not pertain to you, okay?
All right.
In regards to Clinton Prentice, number 414870, we have counsel here.
Yes, Attorney Alfonso Sirica on behalf of Mr. Prentice. I am prepared to waive his preliminary hearing today. And the reason why I need to do it on the record was at a difficult time, his counselor at the facility has been out. So I just spoke to my client yesterday and the docket had already printed. That's why I'm doing it on the record. My client does have a case pending in Hartford Court, so he's not being prejudiced in any manner. I did explain to him what a preliminary hearing was and the reason for the waiver. So I am waiving the preliminary hearing on the record today, and we will like to be scheduled for our revocation hearing once that case in court is resolved.
So accept the waiver on the record for Clinton Prentice, number 414870, and his revocation hearing will be scheduled upon disposition of pending charges.
Thank you.
Thank you. Have a good day.
That's it, right? For me?
For you, yes.
Yeah.
Regarding inmate Thomas Collier, number 372296, preliminary hearing has been waived by counsel. Regarding inmate Jose Torres, number 407984, preliminary hearing has been waived by counsel. He will be scheduled for a revocation hearing upon disposition of pending charges. Okay, I'm just gonna get your attorney, sir, then we'll get started.
Okay.
All right, we're gonna get started with your revocation here, sir. Good morning, I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Topher Edward number 405078. Today is July 14th, 2026. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing, and public access to the hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
405078, Edward Francis Topier.
Thank you. And we have counsel here today.
Yes, Hannah Dean on behalf of Mr. Topier.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact with each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is releasing and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make recommendation as the appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay. Your important rights today, the right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
I believe so, yes.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we will now review the charge the state appeal is bringing against you and the information underlying each charge. The charge 1, obey all laws, obedience to the law. Your charging officer reported on 1/16/26. You were at the victim's residence in Pounds Avenue, New Haven. You violated an active restraining order with your wife, victim LB. Subsequently, New Haven Police Department a summons for the criminal charge of violation of restraining order without escort of police. And the state has filed the following exhibits that are pre-marked for identification as Exhibit A, Connecticut conditions of parole. B, Connecticut Board of Parole remain actual custody order. C, notice of parole violation. D, parole violation report. E is New Haven Police Department report ending in 2114. Did you receive notice of parole violation report, and the other documents that I marked, and did you review them?
I believe so. I'm not sure every.
Counsel, did you review them?
Yes, I did receive everything, and my client and I did have opportunity to speak and prepare. Thank you.
Okay. So council's filed the following exhibits pre-marked for identification as Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. A Defense Exhibit 2, which is New Haven Superior Court order, and Exhibit 3, which is New Haven Superior Court transcript. Do you need to continue the hearing to obtain any additional evidence?
We do not, thank you.
We have no witnesses today. So is now defense's opportunity. If you'd like to present evidence and speak to any of the evidence submitted at this time.
Yes, I would just ask if you would swear in Mr. Tobier.
Sure.
I just have maybe one question.
Can you please raise your right hand, sir, so I can swear you in? You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Okay.
Thank you very much. You can put your hand down. Thank you. I just want to start by noting we're not denying or contesting the fact that there was a conviction. Oh, did you read the addendum?
Oh, sorry.
I'm sorry.
Yeah, no, there was an addendum that was submitted by PCS. The addendum states on 6/9/26, subject appeared in New London Superior Court, GA 10. Under docket ending in 4064-S, subject was sentenced on charges of criminal violation of restraining order. Subject was sentenced to 5 years, execution suspended after 1 year, followed by 5 years probation. A standing criminal protective order was also issued in the case.
Thank you. Yeah, so I did just want to start by noting we're not denying or contesting the fact there was a conviction in this matter, but there are a few things that I wanted to put on the record concerning the circumstances surrounding this arrest and plea. First, we did submit as an exhibit the family court judge's order from May 8th, 2026. There was a hearing on that date, in addition to the transcript that we submitted from that hearing, which I think to some degree speaks for itself. This hearing occurred after the alleged violation in this case, and it did result in a dismissal of the pending protective order. And I will just note in that decision, the judge indicated the initial application was based largely on the petitioner's concerns that are not necessarily pertinent or viable at this time, such as her fear of immigration consequences, despite already being a lawful United States citizen. As to specific facts in the present case, I would just note that the protective order in issue was extended during a virtual hearing on 12/12/25, and then was thereafter supposed to be mailed to Mr. Tobier at the correctional facility, so he had a physical copy. Mr. Tobier, did you receive that physical copy of the 12/12/25 protective order while incarcerated?
No, I did not.
Thank you very much. I will just note, as is indicated in the transcript, the allegations of violation are that my client went to his son's basement apartment in the residence to collect his personal belongings. Mr. Tobier has indicated that at this time, the complainant was living at a different residence and only his son was residing at that specific property in question. There are no allegations that my client had direct contact with the complainant or that anything violent or concerning occurred whatsoever. In fact, as it is indicated in the transcript, the complainant was somewhere else at the time that this alleged violation occurred. And upon observing my client on her security camera at the home, she then traveled to the home as opposed to going directly to the police to report the issue. When my client was arrested on this matter, my understanding is that he was initially not given a bond, and was given essentially just a summons to go to court. And I will just note, based on that information, I would argue that this is certainly not a willful or purposeful violation on Mr. Tobier's behalf. Again, we're not contesting that there was a conviction in this case, but I do think it adds some clarity. And we would at the appropriate time like to speak to his background and his future plans for parole reinstatement. Thank you.
Right, so what I'm gonna do next is I'm gonna announce my findings in regards to that one charge. So regarding charge one, I do find you violate the conditional bail laws, obedience to the law, based on your conviction of criminal violation of restraining order and received a sentence of 5 years, execution suspended for 1 year with 5 years probation. Also based on exhibits in support of the violation, which is exhibits A, D, and E. I will note the parole eligibility date is 12/1/26 with an EOS date that is now 6/1/27 for this new conviction. So that includes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to determine what outcome I will recommend. So if you would like to at this time.
Thank you very much. My client, Mr. Tobier, is 61 years old, born and raised in the Springfield, Agawam, Massachusetts area. My client received significant support from his father, his 3 sisters, and his adult son. My client is his father's caretaker and had previously been residing with him and taking care of him prior to his incarceration. He does also have 3 children. Upon release to parole in January of 2026, my client was sponsored by a longtime family friend at a private residence. He does have a strong educational background and holds various degrees, including a bachelor's in electrical engineering and a minor in nuclear particle physics from Western New England University. And he also holds an MBA and a Master of Program and Project Management from George Washington University. My client's last employment was for approximately 4.5 years as a senior structural engineer for Materials Inc. until he was remanded. He does have a medical history, including type 1 and type 2 diabetes. While being incarcerated at Robinson Correctional, he reports working in the laundry department. He has had no DRs during this period or any period of incarceration. He does not get into trouble at all in the facility. Upon reinstatement of supervision, my client would like to be sponsored by his longtime family friend, Ms. Fontanella, at the provided address. I will get her phone number and send that over as soon as I have it. My client also reports that he has multiple employment opportunities as a structural engineer or as a superintendent of construction within the state, one of which is through General Dynamic Electric Boat, but he's open to all opportunities. I am asking that you would consider re-paroling Mr. Tobier for that earliest potential date of December 1st, 2026. He has been incarcerated since January of this year and has already served approximately 6 months of time on the matter, for which he unfortunately was not given jail credit due to the nature of his underlying parole. This is his first violation on this term of parole, and I know he is very eager to get back into the community, get back on his feet, and get back to work. Mr. Topier, is there anything concerning your future plans or your past accomplishments I didn't cover that you wish to say at this time?
Just the fact that my job is so specified. In the state of Connecticut, we use this product called calcium chloride on all the roads in the wintertime. And that product that's sprayed down on the bridges that you see the little white lines on it erodes all the infrastructure. So there's parking garages all over the state of Connecticut. Bridgeport Hospital was one of them. Basically, structurally, it was about to collapse. And I was one of the structural engineers that actually was brought in to actually rehab the garage to prevent a full-on collapse like it was in the Westchester Mall that killed a bunch of people, killed, I think, 4 people. That's the kind of work that I do. I don't have any desire to hurt my wife and the mother of my child. I just wanted warm clothes on a January afternoon. That's all I needed. And although she says she was afraid of me, she immediately left wherever she was at her new residence at 24 Pheasant Hill Road in Woodbridge and drove to New Haven to take a picture of me and report me. I didn't say anything to her. I didn't hurt her. I don't want to hurt her. I have a son with her, and I just want to get back out and be a father. That's all. And be a husband and be a son to my 93-year-old father. That's all.
Thank you very much.
Thank you. So I will be right with you with recommendation.
Thank you.
All right, so I'm gonna just put a few things on the record before I make a recommendation. You were in the community approximately 4 days before you returned to custody for this new arrest, and which resulted in the new conviction that you received for criminal violation of a restraining order. You did receive 5 years probation. That's added on to that 1-year sentence now to follow your incarceration. As I stated, the EOS date was 6/1/27 with the eligibility date for parole for 12/1/26. There's no prior violations on this period of supervision, no misconducts that were noted, although you were only in the community for 4 days. I have read all of the transcripts that were submitted by defense. I've read all the evidence that was submitted by the state. I reviewed everything. I am just concerned a little about the history of threatening behavior that has. I do understand though that there was no threatening behavior noted in any of the transcripts submitted by counsel. So I do note that as well. Based on the information I have, I am going to make a recommendation that parole be revoked and be re-paroled for January 20th of 2027. This is about a year period confined as a sanction. I recommend that the following conditions, which is general no contact with EB and a no contact with the victim LB without PO's permission. My findings go on the parole board on July 30th. So the board can lessen that sanction. They can only lessen it to the date of 12/1/26, which is the eligibility date. So that's the soonest date you can get out. They can agree with my sanction, or they can impose a longer sanction, which probably would be the EOS date if they do want a longer sanction. If they want a longer sanction, then you would be notified. You come back for a supplemental hearing. And before the hearing, the board will provide you with the written notice documenting the reason why they may want to exceed my recommendation. During the supplemental hearing, you would be able to respond to those reasons while in front of the panel on the board. That's only in the event they want to go longer than what I've stated today. If they agree with me, you would be released, as I stated, January 20th, which is the year that you were sentenced for the new conviction. Do you have any?
No, Mr. Tobier, I was just gonna say, I will set up a legal call with you so that we can debrief everything that happened in this hearing, and I can advise you as to the next steps.
Okay,
Do you have any questions?
no,
Okay, you were doing well. I mean, I hope wish you the best out there, because it seems like you're a very bright guy and you got a lot going for you. So I hope things work out for you when you get back out there.
thanks.
So you're all set for today, sir. Good luck.
All right, good afternoon. Are we fully loaded at Central?
Yes, Your Honor.
Fully loaded at South?
Yes, ma'am.
Can you have everybody please rise and raise your right hands for me?
Everybody rise, raise your right hand.
Hey, wait, right hand, man.
Raise your right hand.
Do you all swear to tell the truth, the whole truth, and nothing but the truth? Please say I do.
I do.
You may be seated. Good afternoon. I am Judge Patey. You are here this afternoon for your first appearance hearing. There are 4 purposes for this hearing and 4 purposes only. First, I will advise you of the criminal charge that has been filed against you. Secondly, I will ask if you have an attorney representing you. If you have hired counsel and they are present, they will speak on your behalf. If your attorney is not present, you will have the option of proceeding forward with your hearing today or postponing it until tomorrow. If you postpone your hearing until tomorrow, it is your responsibility to contact your attorney to let them know that you will have court. No one else will make that call for you. If you wish to move forward without your attorney present today, we can do that. If you do not have an attorney, I will ask if you can afford to hire one. If so, we will make note of that and move on. If not, and you qualify, I can provisionally appoint the Office of a Public Defender to represent you pending you filling out an application. You have a right to have your attorney present before and during any questioning. You also have a right to communicate with counsel, family, or friends, and if necessary, you will be provided reasonable means to do so. Third, if there are any challenges to probable cause, I will address those. And finally, I will review your bonds and/or other release conditions with you to determine if any changes are necessary to those. Be aware if this court places you on pretrial release today, regardless of whether it is straight pretrial release or a condition of your bond, the conditions announced in court today go into effect immediately, meaning even while you remain in custody. So if you are given a no contact order, it is in effect immediately. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located, as well as where all of you are located, is being recorded. There is an assistant state attorney present listening to everything that is being said, so do not say anything about the crime itself. Please keep these rights in mind as we go through this entire process. For those of you appearing virtually, if you are a non-lawyer, you are to keep your device on mute during the entire time that you are present. In addition, you are not to turn your video feed on at any time. For the lawyers present, please keep your device muted. However, please do turn on your video so the court is aware that you are present. For all of those present, pursuant to the rules of judicial administration, this meeting is not to be recorded in any form unless you are the press and you have prior permission from court administration. Do we have Ms. Baglini, I see. Are you present, ma'am?
Yes, Your Honor.
You'll raise your right hand for me. Do you swear to interpret from English to Spanish and Spanish to English to the best of your ability?
I do.
Thank you, ma'am. You'll do the speech.
Atención, esta es su audiencia de primera comparecencia y tiene solamente 4 propósitos. Primero, informarle sobre el cargo o cargos presentados en su contra. Segundo, preguntarle si ya le está representando un abogado. Si ya contrató uno y este se encuentra presente, el abogado hablará en representación suya. Si su abogado no se encuentra, usted tendrá la opción de proceder con su audiencia de hoy o posponerla hasta mañana. Si usted decide posponerla, será su responsabilidad contactar a su abogado para hacerle saber que tendrá una audiencia. Nadie más hará esto por usted. Si desea proceder sin que su abogado esté presente, puede hacerlo. Si no tiene abogado, le preguntaré si puede pagar uno. Si puede, tomaremos nota de eso y procederemos. Si no puede y califica, la jueza le asignaría provisionalmente la oficina del abogado de oficio para que le represente en espera de que llene la solicitud de estos servicios. Usted tiene derecho a que un abogado esté presente antes y durante cualquier interrogatorio. Tercero, si hay alguna objeción en cuanto a motivo fundado, estas se abordarán inmediatamente. Finalmente, estaré revisando sus fianzas y otras condiciones de liberación para determinar si es necesaria cualquier modificación. Debe saber que si la juez lo pone hoy bajo libertad condicional, independientemente de si es directamente o como condición de su fianza, las condiciones que se anuncien en esta audiencia entran en efecto inmediatamente, aunque usted esté encarcelado. Durante todo este proceso tiene el derecho constitucional de permanecer callado. Si decide no guardar silencio, todo lo que diga podrá ser usado en su contra. Todo lo que se diga donde se encuentra la juez y donde se encuentra usted está siendo grabado. También está presente un abogado de la fiscalía escuchando todo lo que se dice. Por favor, no diga nada sobre el delito en sí y recuerde sus derechos durante el transcurso de este procedimiento y pase al frente cuando se llame su nombre. Gracias.
Hilo Garcia. Sir, you are here charged with domestic violence battery. Do you have an attorney?
Señor, está aquí acusado de violencia intrafamiliar por agresión física. ¿Ya tiene usted un abogado?
No sé si se encuentra presente. Quiero saber.
I'm not sure if the lawyer is present. I would like to know.
Okay, have you hired an attorney, sir? That's the question.
Señor, la pregunta es que si usted ha contratado un abogado.
No he tenido comunicación ni con mi familia ni con el abogado.
I have not been in communications with my family or the lawyer.
Okay, can you afford to hire an attorney?
¿Tiene usted los medios económicos para contratar un abogado privado?
Sí.
I do.
All right, sir, we'll indicate that you're going to hire an attorney. I do find probable cause for your charge.
Indicaremos, señor, que usted contratará un abogado. Encuentro que existe motivo fundado para su cargo.
Your bond is set at $5,000.
Se establece su fianza en $5,000.
If you do bond, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release and then calling in every Tuesday.
Si sale bajo fianza, estará bajo libertad condicional y con condiciones que incluirán que contacte a los servicios de libertad condicional personalmente inmediatamente después de su liberación. Luego tendrá que llamar cada martes.
You will not possess any weapons, firearms, ammunition, or knives.
Se le prohíbe tenencia de cualquier clase de arma de fuego, municiones o armas blancas o cuchillos.
You will have no contact with the victim identified in this case.
Se le prohíbe tener contacto y comunicación con la víctima identificada en este caso.
You will stay 500 foot away from the victim, her home, vehicle, place of employment, and/or school at all times.
Y se mantendrá a 500 pies de distancia de la víctima, de su hogar, vehículo y lugar de empleo o escuela en todo momento.
I will give you one opportunity within 48 hours of your release from custody to return to the residence with a law enforcement escort to retrieve your personal belongings.
Le daré una oportunidad dentro de 48 horas de su liberación de la custodia para volver a la residencia con un acompañante de la policía o autoridades para que recoja sus pertenencias personales.
You understand, sir?
¿Comprende, señor?
Sí.
Yes.
Your next court date is July 31st at 8:30.
Su siguiente cita en el tribunal será el 31 de julio a las 8:30.
Thank you.
Gracias.
Diomedes Isidro Hernandez. Sir, you are here because you failed to appear for court on a trespass charge, and then you also have violation of probation.
Señor, está aquí porque incompareció en el tribunal por un cargo de entrada ilegal y también tiene un incumplimiento de probatoria.
Do you have an attorney?
¿Ya tiene usted un abogado?
No.
No.
Can you afford to hire one?
¿Tiene medios económicos para contratar uno?
No.
No.
Sir, I will appoint the office of the public defender. I do find probable cause for the failure to appear as well as the violations of probation.
Señor, le asignaré la oficina de defensores públicos. Encuentro que existe motivo fundado por la incomparecencia y los incumplimientos de probatoria.
Your bonds are as follows. On the failure to appear, $500. On the violations, you will be held no bond.
Sus fianzas son las siguientes. Por la incomparecencia, 500 y por los incumplimientos de probatoria será detenido sin fianza.
Your next court date is July 31st at 8:30.
Siguiente cita del tribunal es julio 31, 8:30.
Thank you, sir.
Gracias, señor.
Luis Miguel Morales Ortiz. So you are here charged with grand theft. Do you have an attorney?
Señor, está aquí acusado de hurto mayor. ¿Ya tiene usted un abogado?
Sí.
I do.
Who is your attorney?
¿Cómo se llama su abogado?
Licenciado Miguel García.
Attorney Miguel García.
Okay, were you expecting him to be here today because he is not present?
El abogado no está presente. ¿Usted tenía la expectativa que él estuviese presente en esta audiencia?
Hasta donde tengo entendido, sí, él iba a estar.
My understanding is that he was going to be here.
Well, do you want to go forward without him or postpone until tomorrow?
¿Quiere usted proceder con la audiencia sin el abogado o aplazar hasta mañana?
Proceder.
To proceed.
All right, sir, I do find probable cause for your charge. Your bond is set at $5,000.
Determino que existe motivo fundado por su cargo. La fianza se establece en $5,000.
Your next court date is August the 4th at 8:15.
Siguiente cita en el tribunal será el 4 de agosto a las 8:15.
Thank you, sir.
Gracias, señor.
Gracias.
Bone Perez. Maybe Yolan Perez. Sir, you are here charged with driving while license suspended or revoked. Do you have an attorney?
Está aquí acusado de conducir con la licencia suspendida o revocada. ¿Ya tiene usted un abogado?
No. No.
No.
Can you afford to hire one?
¿Tiene los medios económicos para contratar uno?
No.
No.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge.
Le nombraré la oficina de defensores públicos. ¿Existe motivo fundado para su cargo?
Your bond is set at $500 and your next court date is July 31st at 8:30.
Establezco su fianza en $500. Su siguiente cita en el tribunal será julio 31 a las 8:30.
Thank you, sir.
Gracias, señor.
Indahira Sina Gonzalez. Ma'am, you are here on a violation of probation. Do you have an attorney?
Señora, está aquí por incumplimiento de probatoria. ¿Ya tiene usted un abogado?
No.
No.
Can you afford to hire one?
¿Tiene los medios para contratar uno?
No.
No.
Sir, ma'am, I will appoint the office of the public defender. I do find probable cause.
Le nombraré la oficina de defensores públicos. Señora, existe motivo fundado.
Your bond is going to be no bond until you see a judge on August the 11th at 12:45.
Su fianza estará en no fianza hasta que vea un juez el 11 de agosto a las 12:45.
Thank you, ma'am.
Gracias, señora.
Ms. Baglini, do you want to make an announcement?
Atención, si alguien más necesitará interpretación al español, levante su mano ahora. Hearing none, may the interpreter be excused.
Yes, ma'am. Thank you so much.
Thank you.
South County, Zachariah Foster. Mr. Foster, you are here charged with 2 counts of domestic violence battery. Do you have an attorney, sir?
No.
Can you afford to hire one?
Yes.
All right, Mr. Foster, we're going to indicate you're going to hire an attorney, sir. I do find probable cause for the charges, but I am going to straight pretrial release you today. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You'll be permitted contact with your brothers, but there's to be no violent contact. Do you understand?
Yes, ma'am.
Next court date will be July 31st at 8:30, sir. Thank you.
Thank you.
Oh, Mr. Zachary Foster, your court date's going to change. It's going to be August 11th at 9 in Lake Alfred. August the 11th at 8:30 or 9 o'clock, and that'll be at the Lake Alfred Courthouse, okay?
Okay.
Thank you, sir. Whitson Hayes, or Haynes. So you are here charged with 2 counts of domestic violence battery. Do you have an attorney?
No.
Can you afford to hire one?
No.
Sir, I will appoint the office of the public defender. I do find probable cause for each of your charges. Your bonds are going to be set at $5,000 on each count. If you do bond, sir, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with either victim identified in this case. You will stay 500 foot away from the victims, their home, vehicle, place of employment, and or school at all times. I will give you one opportunity, if necessary, sir, to return to the residence with a law enforcement escort within the first 48 hours of your release to retrieve your personal belongings. Your next court date, sir, is July 31st at 8:30. Thank you. Aaron Henderson. Henderson, you are here because you failed to appear for pretrial conference on 3 separate charges. You have previously been appointed the Office of the Public Defender. I do find probable cause. Your bonds are as follows: on the driving while license suspended, $1,000; on the possession of cannabis, $2,000; on the possession of paraphernalia, $2,000. Your next court date, sir, will be on August the 26th at 8:30. Thank you, sir. Marvin King.
Yeah.
King, you're here charged of petty theft in the 1st degree. Do you have an attorney?
No, I have an attorney, but I don't have it with me.
All right, did you hire an attorney, sir?
No, I didn't. I had a public defender.
Can you afford to hire an attorney for yourself?
No.
All right, sir, I will appoint the Office of the Public Defender. I do find probable cause for your charge. Your bond is set at $1,000, sir. Your next court date is July 31st at 8:30. Now, I do see that you were out on bond in 26 CF 281. I am revoking your bond in that case, sir, pursuant to a finding of probable cause in this case. You will be held at no bond in that case, sir, pursuant to Parker versus State. Your next court date is July 31st. Thank you, sir. Aaron Meeks. Mr. Meeks, you're here charged of possession of paraphernalia, dumping litter on private property, possession of fentanyl, creating or maintaining a nuisance injurious to public health, unlawful possession of a shopping cart. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Sir, I will appoint the Office of the Public Defender. I do find probable cause for each of your 5 charges. Your bonds are as follows: $1,000 on the paraphernalia, $5,000 on the dumping, $5,000 on the fentanyl, $500 on creating or maintaining a nuisance injurious to health, and $1,000 on the possession of a shopping cart. Your next court date, sir, will be on August the 18th at 8:15. Thank you, sir.
Thank you.
Gary Mizell.
Yes, ma'am.
So you are here on a violation of probation, sir. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Sir, I will appoint the Office of the Public Defender. I do find probable cause. Based upon the warrant, you are going to be held at a no bond, sir, until you see a judge on August 17th at 8:30. Thank you, sir.
Could I represent myself, ma'am?
You certainly can, sir. I'll remove the Public Defender.
All right,
Thank you. Ishmael Rodriguez.
Yes, Your Honor.
So you are here on violation of probation. Do you have an attorney?
No, Your Honor.
Can you afford to hire one?
No, Your Honor.
Sir, I will appoint the Office of the Public Defender. I do find probable cause for your violations. You are going to be held at a no bond, sir, until you see a judge on August the 17th at 8:30. Thank you, sir.
You're welcome, ma'am.
Alvin Ross. Mr. Ross, you are here charged with resisting an officer without... Are you still in the hospital? Okay, thank you. Alec Rowley. Alec Rowley.
Sandra Smith with the Public Defender's Office. I do want to waive the reading of all of his charges and all special conditions of pretrial release.
No, that's to be heard on this.
All right, so Mr. Rowley, are you aware of the charges you're facing, sir?
Yes, Your Honor.
Do you have an attorney?
No, I do not.
Can you afford to hire one?
No, I cannot.
Sir, I will appoint the Office of the Public Defender. I do find probable cause. Actually, there is a warrant, so probable cause was previously established. Mr. Matthews?
Well, Your Honor, with regard to the chart, all the counts are under a statutory, under a statute that is not listed as an enumerated offense as under 97041. So there will not be a motion for pretrial detention as is before the court. I will be requesting special conditions for pretrial release. Judge, I'm going by number to honor the request of defense counsel. Judge, I'm requesting special condition.
The only problem is that we have a warrant that's been signed by a circuit judge, and the only condition that that judge put on the warrant is number 25.
Understand, Judge, the state's position is you can add to that, but.
What else are you asking for?
22 and 22A.
Okay, I'm going to grant that request. As far as a numeric for bonds, the state doesn't wish to be heard on that.
No, Your Honor. Thank you.
All right, Mr. Rowley, your bonds are going to be set at $20,000 on each count, sir. If you do post bond, you will be on a pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will have conditions, sir, number 22, number 22A, and number 25. Those will be explained to you, sir, if you are released from custody. Your next court date in this matter is going to be August the 18th at 8:15, sir. Thank you.
Thank you.
Yes, public defender. Okay. Who's your last person there? You skipped back.
Cameron Francis.
All right, Mr. Francis, I apologize. I skipped over you, sir. You are here on an order revoking your pretrial release on 4 separate charges. Mr. Averbuck, are you here representing him?
I am, Judge, with the PD's office, yes, ma'am.
All right. So Mr. Averbuck is present here on your behalf, sir. I do find probable cause based upon the order that was signed by the court. It is a no bond hold based upon the recommendation or request of Judge Ramirez. So you will see Judge Ramirez on July 31st at 8:29 for a mandatory docketing. Anything additional?
Judge, is there any way we could get a quicker hearing, like a 5-day hearing?
She doesn't approve a 5-day hearing.
Okay.
And I don't think the clerk can really call her office and ask for one since she didn't put it on the KPS, but you can certainly call her office and get a hearing date.
Okay.
All right, thank you,
Thank you,
Mr.
Judge.
Averbuck.
I'll talk to you soon, Mr. Francis.
Thank you, Mr. Francis. Thank you, South County. Have a good afternoon.
Yes, ma'am, you do. Thank you.
All right, sir, you are Mr. Love, Joshua, correct?
Yes, ma'am. Good morning.
Good morning, good afternoon, actually.
Good
Sir,
afternoon.
you are here charged with domestic violence battery with a prior conviction. You have Nicole Gaines representing you.
Yes, Your Honor.
Okay, have you hired her to represent you on this case, or does she represent
Is this
you?
the case from 2025?
This is a 25 case.
Yes, Your
Okay.
Honor. She should be.
Okay, so, sir, we do show that Ms. Gaines is representing you. Let me see this. That's the only warrant that was served. I can see this, but I understand this. Okay. All right, so sir, you are here on a KPS that was served on you. The court did not set a bond, so I am going to set your bonds. Oh, they did set a bond at $5,000. All right, they did set a bond at $5,000, sir.
This is for the one that was issued where they discharged bond, they reinstated the
I don't
discharge
know,
bond.
sir. All I know is that you're here in front of me today on this KPS that they've served on you. You've got a bond of $5,000. If you do bond, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will have no contact with the victim identified in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and or school at all times. You understand?
Am I allowed to return or pick up my belongings?
I can allow you to do that. I'll give you one opportunity within 48 hours of your release from custody to return to the residence with a law enforcement escort to retrieve your personal belongings.
Thank you, Your Honor.
All right, yes. Yeah, well, you're also not going to possess any weapons, firearms, ammunition, guns, or knives, okay, sir? Your next court date right now, so why is it so far away?
We had pretrial this morning.
Oh, well, then you have court again on September 1st, apparently. All right, thank you, sir.
Thank you, Your Honor.
Catherine Bardalis. And you are here charged with forgery, uttering a forged instrument, grant theft, fraud, 2 separate counts. Do you have an attorney?
No, ma'am. I'll need a public defender.
Okay, let me ask the questions and then you answer them, okay? Can you
Okay.
afford to hire an attorney?
No, ma'am.
All right, ma'am, I will appoint the office of the public defender. I do find probable cause for each of your 5 charges. Your bonds are as follows. Why does it say VOP? These aren't VOPs. These are.
It's actually a VOP, Your Honor.
Oh, why doesn't it say that?
That was a capious when it initially
Okay.
came through on the charges.
Okay, so these are actually violation of probations, ma'am, so they're not new charges, just so you're aware. So I will appoint the office of the public defender. You are going to be held at a no bond status on counts. See, this doesn't make any sense to me. That can't be right. That's old.
We're here, I believe in the arrest warrant that from June.
Yeah, this is a
of this year.
case. Yeah, that's old, patrol. That's why you're confusing me. That's not what they're here on. or she's here on. Yeah, so let me look here. Yes, this is a warrant. So ma'am, you are going to be held to no bond until you see a violation of probation judge on, what's the date? August 17th at 8:30, ma'am. Thank you.
Thank you.
Michaela Beard.
Sanderson's let the
Yes.
off. Never qualifies challenge on one of the charges.
Ma'am, you're here charged with assault on a law enforcement officer, resisting an officer without violence, and breach of peace or disorderly conduct. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. Ms. Smith?
I have a qualifies challenge on the assault on law enforcement. My understanding is, reading the police report, all she says is the officer is, "I'm going to punch you in your face." The statute 784.011, it says a threat to do, by word or act, to do violence to a person with, coupled with ability to do so. And this is the part the officer leaves out, doing some act which creates a well-founded fear in such other person that such violence is imminent. There's no allegation that she raised her fist to punch him, or she started walking toward him.
Ma'am, don't say anything.
There's no allegation for the overt act that's needed in furtherance of the threat, because words alone is never enough for an assault.
Mr. Matthews?
Judge, taking the rest of the affidavit into consideration, I believe that element is satisfied for the purposes of probable cause. If the court disagrees, I will request 24 hours to perfect, to put those details before the court.
All right, I will give the state 24 hours to gather additional details on that count, ma'am. However, for purposes of today, I am going to give you a bond, so I will find no PC, but I'm going to give you a bond just in case you decide you want to bond out today. So on the assault on a law enforcement officer, it will be $1,000. On the resisting, it's $1,000. On the disorderly conduct, it is $500. If you do not bond, ma'am, you will be brought back to first appearance tomorrow on that assault count, okay?
Thank you.
Thank you, ma'am. Tiara Brown. Ms. Brown, you are here charged with domestic violence battery. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. I do find probable cause for your charge. I am going to straight pretrial release you on this case. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. I will give you one opportunity, if necessary, ma'am, to return to the residence with a law enforcement escort to retrieve your personal belongings within 48 hours of your release. Do you understand, ma'am?
Yes, ma'am.
Your next court date is going to be on August the 13th, ma'am, at 8:30, okay? Thank you.
Okay.
Jalissa Carson. Ms. Carson, you are here charged with criminal mischief, ma'am. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. Look at this one again, because I made a weird note. No, I don't understand it. So, yeah. Ma'am, I do find probable cause for your charge. I will appoint the public defender. I am going to straight pretrial release you on this case, ma'am. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. Do you understand, ma'am?
Yes, ma'am.
Your next court date is August 13th at 8:30, ma'am. Thank you. Shakira Clayton.
Yes, ma'am.
You are here charged with aggravated assault with a deadly weapon and battery. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. I do find probable cause for your two charges. Your bonds are as follows. On the aggravated assault, it will be $5,000. On the battery, it is $1,000. If you do bond, ma'am, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. Do you understand?
Yes, ma'am.
I understand that you live in Georgia. Is it your intent to return to Georgia?
Yes, ma'am.
All right, I'm going to permit you to return to Georgia, ma'am, but you are required to appear for all of your court dates here in Florida. Do you understand?
Yes, ma'am.
Next court date is August the 4th at 8:15. Thank you, ma'am.
Thank you.
Tess Davis.
Yes, ma'am.
Ms. Davis, you are here charged with possession of paraphernalia, possession of a controlled substance without a prescription, and possession of meth. Do you have an attorney?
No, ma'am.
Do you afford to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. I do find probable cause for each of your 3 charges. Your bonds are as follows. Davis, Tess Davis. Your bond on the possession of paraphernalia is $1,000. Possession of a controlled substance without a prescription, $5,000. Possession of meth, $5,000. Your next court date is August the 18th at 8:15, ma'am. Thank you.
Thank you.
Wanda Hutchins.
Yes, ma'am.
Hutchins, you are here because you failed to appear for court on a driving while license suspended charge. Do you have an attorney?
No, ma'am.
Can you afford to hire one? Can you afford to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is set at $500. Your next court date is July 31st at 8:30, ma'am. Thank you.
I have my license. The ticket.
Here,
Yes.
you are here on a violation of probation. Do you have an attorney?
No.
Can you afford to hire one?
No.
Ma'am, I will appoint the office of the public defender. I do find probable cause based upon the warrant. You are going to be held Laguerre, L-A-G. You are going to be held at a no bond until you see a judge on August 17th at 8:30, ma'am. Thank you. Jennifer Slater,
Yes, ma'am.
you are here on an order revoking your pretrial release. It is a no bond hold. You are represented by Mr. Lagori.
Yes, ma'am.
You are going to be held no bond. I do find probable cause. Your next court date will be August the 6th at 8:30, ma'am. Thank you.
Thank you.
Chemdelay Thea Smith. Ma'am, you are here out of Leon County. You do have a bond. It looks like it's $150. So if you can afford to post that, you can post that from Polk County and get released. If not, we're going to notify Leon County that you are in our custody and ask them to come and pick you up. If they do not pick you up by July 21st at 1 o'clock, we'll bring you back to first appearance. All right, ma'am? Thank you.
All right.
Jessica Sprouse. Ms. Sprouse, you are here in violation of probations. You have an attorney.
No, Your Honor.
Can you afford to hire one?
No.
Ma'am, I will appoint the office of the public defender. I do find probable cause based upon the warrant. You are going to be held no bond until you see a judge on August 17th at 8:30. Thank you, ma'am.
Thank you.
Olivia Stahl. Olivia Stahl. Ms. Stahl, you are here charged with possession of cannabis over 20 grams, possession of paraphernalia, keeping a public nuisance structure for drug activity, and loitering or prowling. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
And I will appoint the office of the public defender. I do find probable cause for each of your 4 charges. Your bonds are as follows. Possession of cannabis over 20 grams, $5,000. Paraphernalia, $1,000. Keeping a public nuisance structure for drug activity, $5,000. Loitering or prowling, $500. Your next court date will be August 18th at 8:15. Thank you, ma'am.
Excuse me, Your Honor. I do have a medical marijuana card.
Okay, that doesn't mean anything to me today, ma'am. Thank you. You may step over. Crystal Sidek. And you are here on a violation of probation out of Lake County. It is a no bond hold. We are going to notify Lake County that you are in our custody and ask that date up there is incorrect. Ask them to come and pick you up. If they do not pick you up by July the 21st at 1 o'clock, ma'am, you'll be brought back to first appearance, okay?
Thank you.
Tamara Torres Bonet, or Bonnet.
Yes,
You
ma'am.
are here on a violation of probation. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. I do find probable cause based upon the warrant. You are going to be held no bond until you see a judge on August 17th at 12:45. Thank you, ma'am. Zanaya Torres. Ms. Torres, you're here charged with driving while license suspended or revoked. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Ma'am, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is set at $500. Your next court date is July 31st at 8:30, ma'am. Thank you.
Well, thank you.
Apollonia Vargas. Ma'am, you are here charged with domestic violence battery on a person over 65. Do you have an attorney?
No,
Can you afford to hire one?
no,
Ma'am, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is going to be set at $5,000. If you do bond, you are going to be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and they will call in every Tuesday. You will be subjected to random urinalysis at your own self-pay. You will not possess any weapons, firearms, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. I will give you one opportunity within 48 hours of your release from custody to return to the residence with a law enforcement escort to retrieve your personal belongings. Do you understand, ma'am?
yes, ma'am.
Your next court date is August 18th at 8:15, ma'am. Thank you.
Judge, I'd ask for no alcohol conditions based on
I
the
thought it was
evidence.
drugs, not alcohol, but.
I'm sorry?
I thought it was drugs, and that's why I did the random urinalysis, but if it's alcohol too. Ma'am, I'm going to order that you not possess or consume any alcohol, nor go into any bars, lounges, or package stores as well. Do you understand?
Yes, ma'am.
Thank you. Yes. Yeah. Janet Wilson. Ms. Wilson, you are here on violation of probations. Do you have an attorney?
No, ma'am.
Afford to hire one?
No, ma'am.
I will appoint the office of the public defender. I do find probable cause. You are going to be held at no bond until you see a judge on August 17th at 8:30. Thank you, ma'am. Brian Acosta. Sir, you are here charged with domestic violence battery. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is set at $5,000. If you do bond, sir, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. I will give you one opportunity within 48 hours of your release from custody to return to the residence with a law enforcement escort to retrieve your personal belongings. Do you understand, sir?
Yes, ma'am.
Your next court date is July 31st at 8:30. Thank you. Jim
Thank you.
Bozuto. So you are here on violation of probations out of Orange County. We are going to let them know that you are in our custody and ask them to come and get you. If they do not pick you up by July 21st at 1 o'clock, you'll be brought back to first appearance. Thank you, sir. Jonas Castro. Mr. Castro, you're here charged with possession of cannabis less than 20 grams. Sorry, Mr. Burton, I'll come back to you. And possession of paraphernalia. Do you have an attorney?
No,
Can you afford to hire one?
no.
Sir, I will appoint the office of the public defender. I do find probable cause for your charges. I am going to straight pretrial release you on these counts. Conditions will include you contacting pretrial services in person immediately upon your release and then calling in every Tuesday. You'll be subjected to random urinalysis, sir, at your own self-pay. Your next court date will be July 31st at 8:30. Oh, that's going to change. August 13th at 8:30, sir. Thank you.
All right.
Kathleen Burton. Mr. Burton, you are here charged with criminal mischief, sir. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge. I don't want to put you on pretrial release, sir, but please don't go back to Beef O'Grady's, okay?
Yes, ma'am.
Next court date is August 18th at 8:15. Thank you, sir.
Thank you.
5,000. Jeremy Donnelly?
Santa Cruz Public Defender's Office, alleged victim wants to have contact
Yes.
with him and doesn't want to press charges.
Sir, you are here charged with domestic violence battery. Do you have an attorney?
No.
Can you afford to hire one?
No.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge. I am going to straight pretrial release you on this case. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not possess or consume any alcohol, nor go into any bars, lounge, or package stores. You'll be subjected to random breath testing at your own self-pay. You'll be permitted contact with the alleged victim, but there is to be no violent contact. Do you understand?
I understand.
Your next court date is August the 12th at the Lakeland Courthouse at 8:30 in the morning, sir. Thank you.
Thank you.
Justin Elfils. Sir, you are here charged with assault on a person 65 years of age or older. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, I need a public defender.
And can you afford to hire one?
Not at all.
Okay, you don't have to lean into the microphone like that. I can hear you, okay?
My apologies.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is set at $1,000, sir. If you do bond, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not use, possess, or carry any firearms, guns, ammunition, or knives, and you'll have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. I will give you one opportunity, if necessary, sir, to return to the residence with a law enforcement escort within the first 48 hours of your release to get your personal belongings. Do you understand?
Yes, ma'am.
The next court date is July 31st at 8:30, sir. Thank you. John Navies Fuentes.
Yes, ma'am.
Sir, you are here charged with possession of cannabis and possession of paraphernalia. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your 2 charges. Your bonds are set at $1,000 on each count. Your next court date is July 31st at 8:30. Thank you, sir.
Thank
Your Honor, if I may,
Yes?
I'm showing an open case NM 263778. Stated request to Parker Hold in that case.
3778.
Yes, ma'am.
All right, Mr. Fuentes, apparently you have an open case, sir, that you are out on bond on. So I am going to be revoking the bond in that case pursuant to a finding of probable cause. In this case, you will be held no bond pursuant to Parker versus State. You understand?
Yes, ma'am.
Thank you, sir. Xavier Gallo. Mr. Gallo,
Yes,
you are
ma'am.
here because you failed to appear for your mandatory docketing. Do you not have an attorney representing you on this?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. It is a no bond hold, sir. However, you are going to see the judge on July 15th, which is tomorrow at 8:30, for him or her to decide if they're going to give you a bond, okay? Thank
Okay.
you.
Thank you.
Jerome Goldwire, and I didn't have any paperwork on this guy, so I need to see the PC. Sir, you are here I'm sorry? Okay. You are here charged with resisting an officer without violence, possession of paraphernalia, possession of cocaine, and possession of a weapon or ammunition by a convicted felon. Give me a minute to read your paperwork. You still don't have it. State, can you bring up that?
Yes.
Or somebody, I think the clerk's got it for me, Mr.
Yes, ma'am.
Thank you. Thank you. Automatic option here. Hold on 1 second. All right, sir, I do find probable cause for each of your 4 charges. Your bonds are as follows. On the resisting, 1,000, possession of paraphernalia, 1,000, possession of cocaine, 5,000, on the possession of weapon or ammunition by a convicted felon, 20,000. Your next court date will be August 18th at 8:15. Thank you. I did appoint the public defender.
Thank you.
Devon or Devin Haynes, or Hagan, excuse me. Sir, you are here charged with domestic violence battery by strangulation. Do you have an attorney?
No, ma'am.
Afford to hire one.
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your charge. Your bond is going to be set at $7,500. If you do bond, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. Sir, I'm talking to you. Don't talk. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will not possess or consume any alcohol, nor go into any bars, lounges, or package stores. You'll be subjected to random breath testing at your own self-pay. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. I will give you one opportunity within 48 hours of your release from custody to return to the residence with a law enforcement escort to retrieve your personal belongings. Do you understand these conditions?
Yes, ma'am, but Your Honor, I'm gonna need more than just that one visit. If I get out tonight on the bond, I gotta go to work 5 o'clock in the morning, and then I got a whole house to move.
Okay, sir. Well, you're not going to get it. You're going to get one opportunity within 48 hours. Your attorney can file a motion with the court and they can give you more time. But for now, you're going to get your personal belongings and that's it. Your next court date is August 18th at 8:15. Thank you. Keith Holm. So you are here charged with possession of paraphernalia, violating the financial responsibility law, possession of cannabis over 20 grams, and driving while license suspended or revoked. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your 4 charges. Your bonds are as follows: $1,000 on the para, $500 on the violation of financial responsibility, $5,000 on the possession of cannabis over 20 grams, and $500 on the driving while license suspended. Your next court date is August 18th at 8:15. Thank you, sir. Isaiah Jean Louis. Sir, you are here on violation of probations. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause based upon the warrant. You are going to be held no bond until you see a judge on August 17th at 8:30, sir. Thank you. Jeffrey Jones.
Yes, ma'am.
I have a qualified challenge on one of the charges.
Mr. Jones, you're here charged with possession of paraphernalia and possession of a synthetic drug. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. Ms. Smith?
You know, I don't have a lot of information on this. It's like only 3 paragraphs. This is from something that occurred back on October 31st in 2025, and they just had got it back from the FDLE confirmed, I guess, to be synthetic cannabis. But my challenge is on the paraphernalia. All it says is that it was found in his right front pants pocket. It doesn't say it was in a baggie or any container or anything. So I do have a qualified challenge on the paraphernalia part of this case.
Mr. Matthews? All right, so
I meant
sir.
to tell Ms. Smith that before court she didn't inquire. I apologize for
Okay.
carrying it back.
So, sir, on the possession of paraphernalia, we'll find no probable cause. You'll be ROR'd on that. On the possession of the synthetic drug, the bond is set at $5,000. Your next court date is August 18th at 8:15, sir. Thank you.
Yeah.
Richard Lane. Mr.
Yes,
Lane.
Your Honor.
Loitering or prowling, possession of paraphernalia, possession of cannabis less than 20 grams, and possession of Xanax. Do you have an attorney, sir?
No, Your Honor.
Afford to hire one?
No, Your Honor.
Sir, I will appoint the office of the public defender. I do find probable cause for your charges. Your bonds are as follows: on the loitering or prowling, $500, paraphernalia, $1,000, possession of cannabis less than 20 grams, $1,000, and possession of Xanax, $5,000. Your next court date is August 18th at 8:15, sir. Thank you. Samuel Lepore.
Yes, ma'am.
You are here charged with driving while license suspended or revoked from another state while your Florida driver's license is suspended, possession of paraphernalia, possession of cannabis less than 20 grams, driving under the influence, and then possession of cannabis resin. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
Yes, ma'am.
All right, will indicate you're going to hire an attorney, sir. I do find probable cause for your charges, sir. Your bonds are as follows: on the driver's license charge, $500, paraphernalia, $1,000, possession of cannabis, $1,000, driving under the influence, $1,000, and the possession of cannabis resin, $5,000. Your next court date is August 18th at 8:15, sir. Thank you.
Thank you, ma'am.
Dallas Love.
Sanders Smith, Public Defender's Office. I do have one call.
Mr. Love, you're here charged with possession of burglary tools with intent to use, resisting an officer without violence, 2 counts of possession of paraphernalia, 1 count of possession of methamphetamine, and possession of fentanyl. Do you have an attorney, sir?
No, ma'am.
Can you afford to hire one?
No, ma'am.
All right, sir, I will appoint the office of the public defender. Ms. Smith?
Actually, I have a qualified challenge on the possession of burglary tools charge. all it says in the whole affidavit is additionally, the search of the backpack revealed items consistent with burglary tools. That's a conclusory statement saying that whatever they found are burglary tools, but we don't know what they found, whether they're bolt cutters or what. They didn't list the actual burglary tools in the affidavit.
24 hours state.
Your Honor, it was my intention to do that. However, I am going to request that the bond be revoked in NM 265146. And if he's going to be held no bond, then I will. It was my intent to do that, but once I realized that I was requesting that Parker hold, then I'm not going to fight that.
All right, so Mr. Lowe, will find no probable cause for the possession of burglary tools, sir. You will be ROR'd on that count. On the resisting, it's 1,000, paraphernalia, 1,000. Each of the paraphernalia is 1,000. Methamphetamine, 5,000, and the fentanyl is 5,000. Your next court date on these charges, sir, will be August 18th at 8:15. I do see that you are out on bond in 26 MM 5146. I am revoking your bond in that case pursuant to a finding of probable cause. In this case, you will be held at no bond in that case pursuant to Parker versus State. Do you have the public defender in that case, sir?
He does.
Okay. All right, sir, thank you. No PC and
I would close that.
Man, no PC, yes. Taylor Bateman. Sir, you are here on a warrant. It's someplace else, but it doesn't say on my paperwork.
It's Henry.
Hendry County, it is a no bond hold for violation of probation. We are going to notify Hendry County that you are here and ask them to come and pick you up. If they do not pick you up by July 21st at 1 o'clock, you'll be brought back to first appearance. All right, sir, thank you. Next is Christopher Murphy, and I did not have paperwork on him either.
I'll request to be heard on that one.
I had an email from, I guess, the court saying he was a takeoff for some unknown reason.
He's unable to appear due to medical.
I asked her, we set it tomorrow.
Okay, then we'll bring, maybe that's why I didn't have paperwork. We'll bring Mr. Murphy back tomorrow. Bobby Nimmons. Mr. Nimmons, you're here charged with resisting an officer without violence, possession of paraphernalia, and possession of fentanyl. Do you have an attorney?
No, can I say something?
No, sir, I'm going to go through my thing first, okay? Can you afford to hire one?
No, ma'am.
Sir, I will appoint the Office of the Public Defender. I do find probable cause for each of your 3 charges. Your bonds are set at 1,000 on the resisting, 1,000 on the paraphernalia, 5,000 on the fentanyl. Your next court date will be August 18th at 8:15. Now, what do you want to say?
Ma'am, they asked me what a stomach pill was that I had in my pocket.
Sir, don't
Alright,
talk to you. Don't say anything. You're just going to hurt yourself, okay? Your next court date is August 18th at 8:15. Thank you. Michael Pinello. So you are here charged with written threats to kill via an electronic device. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the Office of the Public Defender. I do find probable cause for your charge. Your bond is set at $20,000. If you do bond, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, school, place of business. And then you will not possess, access, or use any computer or other electronic device with internet or intranet capabilities. Do you understand, sir?
Yes, ma'am.
Your next court date is August 18th at 8:15. Thank you, sir. Donald Skipper. Mr. Skipper, you're here charged with domestic violence battery. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
Yes, ma'am.
All right, we'll indicate you're going to hire an attorney. I do find probable cause for your charge. Your bond, sir, is going to be set at $5,000. If you do bond, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you'll call in every Tuesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and or school at all times. I will give you one opportunity within 48 hours of your release from custody to return to the residence with a law enforcement escort to retrieve your personal belongings. Do you understand, sir?
Yes, ma'am.
Your next court date is July 31st at 8:30. Thank you, sir.
Thank you.
Timothy Smith. I didn't note the domestic relationship in this case. I may be missing something, but Mr. Smith, you're here charged with domestic violence battery. Do you have an attorney?
Not
No, no, ma'am. He's supposed to be present, but I guess he's not present.
Okay, have you hired an attorney?
No, well, I was supposed to have one, but I wish to proceed.
Okay, so you gotta listen to my question, okay? Have you hired an attorney to represent you? Yes or
No,
no?
no, ma'am.
Can you afford to hire one?
Yes, ma'am.
All right, we're gonna indicate that you will hire your own attorney.
I may have just one more minute, Judge.
Sure. Like I said, I may have missed it, but.
I don't see a mention of it, but it does appear that the affidavit was serving an investigation by another officer. So I suspect that that was in the other affidavit, but I would acknowledge it's not before the court. Because it's a DV allegation, Judge, I would ask for 24 hours to perfect that aspect of it. I don't object to a presumptive bond that would be typical if it were a DV battery, but I would request that the typical DV conditions of pretrial release be attached to that at least for 24 hours. Just at an abundance of caution, because I agree with the court, I can't tell from what I'm reading one way or the other.
All right, so sir, what I'm gonna do is I'm gonna find probable cause for the charge of battery, not for domestic violence battery, okay? I'm gonna
Yes,
set
ma'am.
your bond at $2,500. If you do bond, you are going to be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You will have no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. I will give you one opportunity, if necessary, within 48 hours of your release from custody, to return to the residence with a law enforcement escort to retrieve your personal belongings. Do you understand?
We don't stay together, ma'am. We don't stay
Okay,
together.
and that takes care of that. Now, if you do not bond, then the state has requested 24 hours, so you'll come back to first appearance tomorrow, okay? Because if it is found to be domestic violence, then your bond will increase, okay? So right now, you have a $2,500 bond. So if you bond today, you don't have to come back tomorrow. If you don't bond, you're gonna come back tomorrow. The state's gonna see what they can find, okay?
Yes, ma'am.
All right, thank you, sir. Timothy Spencer.
Yes, ma'am.
Spencer, you are here charged with 5 counts of domestic violence, written electronic threats to kill with bodily harm to another, 1 count of unlawful use of a two-way communication device. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. There is probable cause based upon the warrant that was previously approved. Your bonds will be as follows: $20,000 on each count of the written electronic threat to kill. It will be $10,000 on the unlawful use of a two-way communication device. If you do bond, sir, you will be on pretrial release. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not possess any weapons, firearms, ammunition, or knives. You will have absolutely no contact with the alleged victim in this case. You will stay 500 foot away from the victim, their home, vehicle, place of employment, and/or school at all times. You will not possess or use any computer or electronic device that has internet or intranet capabilities. Do you understand, sir?
Yes, ma'am.
Your next court date is August 18th at 8:15. Thank you, sir. Ramon Torres.
Sandra Smith, Public Defender's Office.
I'm going to straight pretrial release.
Oh, and the victim wants contact.
I know. So, sir, you're here charged with domestic violence battery. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause, but I'm going to straight pretrial release you on this case, sir. Conditions will include you contacting pretrial services in person immediately upon your release, and then you will call in every Tuesday. You will not use, possess, or carry any firearms, guns, weapons, ammunition, or knives. You'll be permitted contact with the alleged victim, but there is to be no violent contact. Do you understand?
Yes, ma'am.
Sir, your next court date will be August 13th at 8:30. Thank you, sir.
Thank
Roman
you.
Turner. Mr. Turner, you are here on a violation of probation, sir. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause based upon the warrant. You will be held no bond, sir, until you see a judge on August 17th at 8:30.
I have one question about, I have probation in Hillsborough County. I've already took the plea in Hillsborough County. Is this warrant due to the DUI when Polk County messed up when they released me from Hillsborough, not extraditing me and picking me up from Polk County?
Sir, I have no idea, but those are great questions for your attorney, okay? Thank you, sir. Matt Walling. Mr. Walling, you
How
are
are you
here in
doing?
violation. Don't speak. Whoever's on the phone, do not say a word. You are here on violation of probations, Mr. Walling. You're also charged with possession of paraphernalia and possession of meth. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for the new charge as well as the violation. You are going to be held no bond on the violation of probation. On your new charges, the possession of paraphernalia is $1,000, possession of meth is $5,000. Your next court date will be August 18th at 8:30, sir. Thank you. Jeffrey Washer. Mr. Washer, you are here charged with possession of paraphernalia, possession of meth, and dumping litter on private property. Do you have an attorney?
No, ma'am.
Can you afford to hire one?
No, ma'am.
Sir, I will appoint the office of the public defender. I do find probable cause for your 3 charges. Your bonds are set at $1,000 on the paraphernalia, $5,000 on the meth, and $5,000 on the dumping. Your next court date is August 18th at 8:15. Thank you, sir. Anthony William. Mr. William, you are here on a warrant out of Hillsborough County. It is for a charge of grand theft. It is a no bond hold, sir. We are going to notify Hillsborough that you are in our custody and ask them to come and pick you up. Actually, yes, ask them to come and pick you up. If they do not pick you up by the 21st of July at 1 o'clock, sir, you'll come back for first appearance. All right, thank you. Thank you, Central. Have a good afternoon. I don't know if there's anything to sign. There was no detainers, but was there one instanter? No, ma'am. No? All right. Then that's it.